Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Natalia Angelini.
And I'm Shawnee Matinnia.
Welcome to Hull on Estates. You're listening to episode number 726.
So today we have a very interesting new Ontario Court of Appeal decision, Stewart Estate and Stewart. So we're going to dive into that as well as its lower court decision, Hale and Stewart. So this case, or both of the decisions, really highlight the difficult balancing act that an executor has to deal with. You know, the will says one thing and the bills say another. What does the executor do? They face personal liability. It's a big issue. So let's get into the background facts of this case.
Right, so high level, this is a case where the testator made a will in 1989, and in that will he granted his wife a life interest in 2 farms. And on her death, one son, Robert, had the option to purchase a farm for $50,000, and the other son, Winfield, had the option to purchase a farm for $90,000. What happened, though, was the testator died just a few years later in 1994, but the wife lived another 25 years and didn't pass away until 2018, during which time the value of those properties skyrocketed collectively to over 1.7 million. And the estate also had a substantial tax liability of, I think, 600,000 or more, for which CRA had registered liens. So this was the framework that the court had to grapple with in terms of what to do.
And because of that, those issues and that serious liability, the estate trustee brought this to the court's attention in an application. She essentially wanted to get the court's permission to be able to sell the farms to satisfy those liabilities. And opposing were Robert's widow. So just a little note, Robert died actually. And so his widow represented his interests on behalf of his estate. So Robert's widow, Lynn, along with Winfield, opposed the estate trustee's application and argued that instead they should be allowed to purchase the farms at the original prices in the will from, again, 1994, even if the debts remained unpaid. So they basically said, we don't care about the debts, just give us our gifts and we'll be gone. However, the application judge said not so fast, and he ordered that the estate trustee could sell those properties because the estate trustee had that discretion to liquidate or deal with the properties in order to pay the debts. And because of this, Lynn and Winfield brought a motion to stay that order pending appeal because, again, they argued the sale would void the gifts that were intended to them.
Right. And just a note, it's interesting to read the lower court decision because I think there were over 20 different issues that the judge had to deal with, and they were within 9 different categories. So it's a good case if you want to learn a bit about a variety of legal issues. But moving on to the appeal, we're looking at when may a stay be granted pending appeal. So the Court of Appeal was looking at this issue, whether a stay should be granted, and typically appealing a court order will not prevent an estate trustee from continuing on to administer the estate pursuant to the original court order. Only if there's a stay granted pending appeal would they be unable to act, right? So what is the legal framework for a stay pending appeal?
So I'd first bring everyone's attention to the Rules of Civil Procedure, specifically Rule 6302, which gets into a stay pending appeal, basically saying the court can grant a stay pending appeal on such terms that are just. And there's actually a test that has 3 prongs, which I'll get into, that must be satisfied in order to meet the criteria to get that stay. And so that was established in a Supreme Court of Canada decision around 30 years ago, RJR McDonald, Inc., and Canada. So the test is 1, a serious question to be tried must be established. 2, the applicant must demonstrate that they will suffer irreparable harm if a stay is not granted. And 3rd, the balance of convenience must favor granting a stay. So ultimately, as we know, the appeals court upheld the lower court's decision. But before we dive into any lessons we might get from this, let's go back and look at the analysis of the McDonald test a bit more.
Right, so for the first prong, a serious question to be decided, the bar is low. It, for example, is the appeal frivolous or vexatious, right? That's a pretty low bar. But the court needs to be satisfied that it has to be arguable that there was an error made by the original trier of fact. And so the Court of Appeals said, there was no serious question to be decided here, even though, the moving parties wanted to have the executor exercise her discretion to sell the properties outright. The executor had concerns about personal liability had she taken that route, right? And the court said this does not raise a serious question to be determined on appeal. So we didn't get more details than that in the decision, but that was where they landed on that first prong.
Yeah, so the court's decision is actually even shorter with respect to the next two prongs. But again, as Natalia suggested, really recommend taking a look at that lower court decision. But getting into the irreparable harm part of the test. So the applicant needs to show that they're going to suffer that irreparable harm if they don't get that stay. And the moving parties, so Lynn and Winfield, their assertions that they would be harmed if they couldn't get these properties, but the court didn't agree. The court found that they weren't able to overcome the fact that both farms were actually being rented to third parties and that the farms weren't really unique. And so any loss suffered by the applicants, so by Lynn and Winfield, if they didn't get that stay, would be purely monetary and ultimately repairable. So they didn't meet the second prong. And then the third prong, balance and convenience. So the court needs to really determine, when it comes to this part of the test, which party is going to suffer a bigger harm or greater harm if a stay is granted or not. And so this part of the test really varies on a case-by-case basis, and it's really dependent on the facts and the reason behind the order and getting into those nitty-gritty details. But again, this part of the test, the court found, nope, you guys don't meet it. They found that the balance of convenience favored the estate trustee's position because ultimately the estate trustee was convincing when she said, well, if we delay this any further and we allow this stay, there's going to be an even greater risk and to the estates. And most importantly, it's with respect to the CRA seizing the property. Because if you guys recall, the CRA had a lien and were ready to take it if they needed to. So the state trustee said this is not in any of our best interests. And the court pretty much agreed.
Right. So the conclusion really was that the RJR McDonald test was not satisfied. And so this motion for stay was dismissed. And we sort of think about, okay, what lessons or takeaways do we have from this outcome?
I think for me, what stands out most is really that balance of the executor's responsibilities and their discretion versus the testator's intentions. And so the courts, again, in this case, made it very clear the executors have a fiduciary responsibility to not only follow the will, but to make sure that the liabilities are satisfied, regardless of whether it overrides gifts. Doesn't matter. At the end of the day, the estate trustee needs to make sure those liabilities are paid and those debts are satisfied. And that was a key responsibility that was really crystallized in this decision for estate trustees.
Yeah.
So sometimes they have to make a hard decision. They have to sell estate assets, even if they were intended to be gifts.
Right. And for me, it also serves as a lesson in estate planning, right? If the estate planning is comprehensively done and potential future liabilities are anticipated or increases in the value of properties over time is contemplated, then maybe this kind of conflict can be avoided. Because look, I mean, here it was almost too good to be true if the beneficiaries did get their way, right? Getting these properties really for a pittance. And you know, to that end, I guess it's a bit of a warning too to beneficiaries, right? Be a bit careful about relying on, you know, the will may say one thing, but when there's significant debts that the executor has to contend with, you know, perhaps it's adjusting, I guess, expectations and getting that independent legal advice so you can better understand, right, how to proceed. So I think that, unless you have any other thoughts, Shawnee, I think that wraps up our review of this case. And until next time, we want to thank you for listening. I'm Natalia Angelini.
And I'm Shawnee Matinnia. If you have any questions, please feel free to email us at info@hullandhull.com, or you can reach us through the contact page on our website. Thanks, everyone.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.